Thank you. அனைவருக்கும் நன்றி. Though this is the third lecture for the Rakesh Law Endowment, and on this occasion we have to remember one person, our beloved Rakesh, our beloved son Rakesh. We are happy to celebrate your birthday, dear son Rakesh, because you are always be here. We are happy to celebrate you because you happen to be the learning process. We are happy to celebrate you because you are the cause for spreading the knowledge in law to the younger generation. We are happy to celebrate you because you are the cause for bringing the law luminaries to this stage to enlighten the lamps. We are happy to celebrate you because you are the cause for removing the dark areas in the field of law and justice. இருளகற்றும் ஒளியாய் உதயசூரியனாய் உதித்து தோன்றி ஒரு பொழுதில் மறைந்தாலும் ஆளா விருட்சமென நிலைத்து பல விழுதுகளுக்கு வேறாய் வாழும் ராகேஷ் உன் புகழ் வாழ்க. Happy birthday to Rakesh. Let us celebrate, please. Thank you.
It was so easy.
Today's
Life was so
lecture,
simple. You were
the
60
third
years.
of its kind of the Rakesh Law Endorsement is going to be delivered by none other than our beloved Justice Muralidhar. Before we start anything, I request Mr. Sundar to come and welcome the gathering. Over to you, Mr. Sundar.
Very good morning to all of you. We are gathered here today for the third annual Rakesh Endowment Lecture for Justice and Equity. As Justice Akbar Ali mentioned, this lecture series was established in the memory of late Rakesh Lango, a cheerful young man and passionate student of law. In the past 2 years, we have been honored to have some distinguished speakers. This year, we are delighted to welcome Dr. S. Muralidhar, former Chief Justice of Orissa High Court and currently a senior advocate at the Supreme Court of India, as our keynote speaker today. I welcome you, sir. Dr. Muralidhar has had a distinguished career in the legal profession. He is known for his commitment to justice and his dedication to the rule of law. He has been a vocal advocate for judicial reforms and has played a key role in the digitization of court records in Odisha. I am pleased to welcome Thiru N.R. Ilango, Senior Advocate and Member of Parliament. Thiru Ilango is not only a renowned lawyer, he is also a passionate advocate for social justice. He'll be formally introducing the keynote speaker today. I also welcome Honorable Justice G.M. Akbar Ali, who will be managing the entire program and also moderating the discussion later. Raghavi S. Agilesh Kumar, trustees of Rakesh Law Foundation. They have been generous to support this lecture series. The Rakesh Endowment Lecture Series, scheduled annually on April 16th to commemorate Rakesh's birthday, serves as a platform for dialogue and reflection on pressing issues of justice and equity. While this year's lecture was postponed due to elections, we remain in our commitment to generating meaningful discussions and advancing the cause of justice. This endowment lecture was constituted at the Roja Muthaya Research Library, which is a library, museum, and archive dedicated to the preservation and promotion of Tamil collective knowledge. It is indeed an honor for RMRL to co-host this lecture series. I'd like to share a few words about the library. Roja Muthaya Library holds an extensive collection of 5 lakh literary gems
But then the funny
in
part of
Tamil
it is similar
and
cases,
issue world
conspiracy
standards
cases.
in documentation and
Trend.
preservation. It is the single largest Tamil collection in the world. 30 years of experience at the RMRL culminated in the idea of creating a Tamil Knowledge Campus. The Tamil Knowledge Campus aims to enable a transformation via education and awareness, making it clear that libraries, archives, and museums are for everyone and are pertinent in supporting democracy. To enhance the appreciation and understanding of several aspects of civilizational knowledge and to democratize it, to promote inclusivity and plurality. It will also be a one-stop place to understand aspects of Tamil language, literature, history, and culture. I must share that a small note here, when Dr. Muralidhar was setting up the judicial archives in Cuttack, in Odisha, he visited a number of places, and the Roja Muthaya Research Library was one of the places, and he invited several experts from all over India to set up the archive there. As an archivist, I'm very happy about that. Now, I extend a warm welcome again to all students, legal professionals, and members of the law fraternity to join us for this enriching discourse. And I invite Dr. Raghavi Lango to share the mission and vision of the Rakesh Law Foundation. But before that, we'd like to honor the guests. May I invite Mrs. All right. So thank you. Over to Dr. Akbar.
Thank you, Mr. Sundar. Of course, I know that he has no time to mention each and every one of the dignitaries over here. The Honorable Minister is here, Mr. Bharati is here, and all the judges are here, all the legal ministers are here. We welcome you all, one and all, on behalf of our family. Actually, today is going to be the third lecture. தோன்றின் புகழொரு தோன்றுக என்றான் என் ஆசான் வள்ளுவன். செயற்கரிய செய்வர் பெரியர் என்றும் சொல்லிச் சென்றான். புகழதூர் தோன்றிய தன் சகோதரனின் பெயரும் புகழும் என்றும் நினைவில் நிற்கும் வகையில் ராகேஷ் அறக்கட்டளை நிறுவி செயற்கரிய ஒரு செயலை எவ்வாறு செய்ய தோன்றியது மற்றும் அதன் அறப்பணிகள் என்ன என்பதை நம்முடன் பகிர்ந்து கொள்ள நம்முடைய அன்பு மகள் டாக்டர் ராகவி இளங்கோ வருகிறார். Please, I welcome Raghav Ilango to present the vision and mission of the trust.
Good morning, everyone. First, I wanted to start by wishing my brother a very happy birthday. And I consider myself very honored today to be eliciting the vision and mission of our foundation. The Rakesh Law Foundation was established in the year 2022 in the fond memory of my dear brother. It would not be wise in not mentioning about the pillars of the foundation who always keep on thinking about the constant working to improve the foundation. So I take this opportunity to thank Justice Rajalingo, Justice Akbar Ali, Justice C.T. Selvam, Mr. Cheran, Dr. Napinai Cheran, Advocate Gandhi Balasubramaniam, Mr. Jayaranjan, Mr. A.S. Selvam, Advocates Mr. Amit Anand Tiwari, AAG Tamil Nadu in Supreme Court of India, Mr. Vivek Singh, Advocate Supreme Court, Advocates Mr. K.S. Ravichandran, K.J. Saravanan, Pachepan from the legal wing of the DMK party, the trustees of the foundation, my mother, Aruna Ilingo, Stalin Mama, Ashwin Prasanna, Agilesh Kumar, and Dr. Ranjit, and all the other juniors who are with my father and contributing to the trust. I really thank you all. Um, so talking about the activities of the trust, we as a foundation have created an endowment with the Roja Muthaya Library. So I sincerely thank Mr. Sundar uh, for encouraging us and being here every year to conduct the series of lectures. The first lecture was given in the year 2022. It was presented by Mr. Kapil Sipal, senior advocate, and most respected journalist, Mr. N. Ram. It was on the topic, is this democracy envisaged by the framers of our constitution? The second lecture was given in the year 2023, and it was by Mr. Abhishek Manu Singhvi, senior advocate, and Mr. Sasikumar on the topic, the pillars of Indian democracy. Following the series of these lectures, the third lecture will be presented today by senior advocate and eminent jurist, former Chief Justice of Orissa, Mr. Muralidharan, of on the topic guilty till proved innocent. As a doctor, I may not understand the breadth and length of the topic, but as a lay person, I know the Indian jurisprudence provides the presumption of innocence till proved guilty, and it's not being followed in many instances. So the lecture will certainly shed light on the subject and will help the young lawyers and the students who are present here. With the fond hope of helping the law students and young advocates and all the general public who wish to understand the law, justice, and equity, this lecture series is organized by the Trust. And this is the vision of our Trust. We are trying to and will certainly accomplish in bringing the best of legal minds to Chennai and deliver the lectures. It will serve as a bridge between those personalities and the young lawyers. And this is the mission of the Trust. The Trust, apart from organizing the series of lectures, have adopted a cooperation school at Amjikare, Chennai. We have provided RO water supply, smart boards, and basic amenities to the school. We have also organized special coaching classes for the students who are aspiring for JEE and NEET. This year, the contract between the Corporation of Chennai and the Trust is to be extended, and it's delayed due to the elections. I hope and believe the mission and vision of my father, Mr. N.R. Elungu, the founder of the Rakesh Law Foundation, to democratize legal knowledge for young law students and the common man can certainly be achieved with the wishes of the elders, support, and the friends by participation of all of you. Thank you all.
Thank you, Raghavi, and you have given a very enlightened vision and mission of our trust. Before I go into calling upon the main speaker, we wish to honor him with a book. I request Sister Arna Ilango to come over the dais and present a book to the Chief Justice, former Chief Justice, today's speaker. It's also a pleasant moment for me because I am also to receive a book from them. Because I know that they know that I am very poor in reading because they wanted me to read a book. Please, Raghu.
I would like to honor Mr. Ragbar.
I assure you, definitely, I will read this and come back to you. Now coming to the main topic. மகன் தந்தை காட்டும் உதவி இவன் தந்தை என்னோட்டான் கொல்லெனும் சொல் தந்தை மகர் காட்டும் நன்றி அவையத்து முந்தியிருப்பு செயல் ஒரு மோப்ப குலையும் மணிச்சமாய் வாடி உதிர்ந்துவிட்ட போதிலும் அதன் மனம் வையகத்தில் என்றென்றும் இருக்கும் வகையில் அவன் பெரியிலேயே ஒரு அறக்கட்டளையை நிறுவி அதன் மூலமாக தனையனுக்கு நன்றி பாராட்டும் ஒரு தந்தையாக நம்மிடையே இருக்கும் நமது அன்பிற்கும் பாசத்திற்கும் உரிய நமது சகோதரர் மூத்த வழக்கறிஞர் மாநிலங்களவை உறுப்பினர் திரு என்ஆர் அவர்களை இன்றைய சொற்பொழிவாளரை பற்றிய தகவல்களை பகிர்ந்து கொள்ள இருக்கிறேன். I request Mr. N.R. Elango to introduce the speaker today.
Honorable Justice S. Muralidhar, Honorable Justice Anand Venkatesh, Honorable Minister for Higher Education, Mr. Purmudi, Mr. Alandur Bharati, Mr. T.K. Silangovan, Justice Akbar Ali, Mr. Sundar, Mr. Balakrishnan IAS, Mr. Jayaranjan, Mr. Kamaraj, eminent doctors, Dr. Vijay Shankar, Dr. Jayakumar, my dear brother, Mr. Ramesh, Senior Advocate, family, I consider all of you as my family and friends. Good morning. இவங்களுக்கெல்லாம் என்ன என் மேலே கோவம்னு தெரியல. டே பிஃபோர் எஸ்டர்டே ஹைகோர்ட்டில் ஒரு ராகேஷ் லா ஃபவுண்டேஷன் எம்பிஏ சேர்ந்து ஒரு லெக்சர் சீரீஸ் இருந்தது. அந்த லெக்சர் சீரீஸில் எம்பிஏல உட்கார வச்சுட்டு ஜஸ்டிஸ் ஆனந்த் வெங்கடேஷை பற்றி இன்ட்ரடக்ஷன் கொடுக்க சொன்னாங்க. அது எப்படி சரியாக இருக்கும்னு எனக்கு தெரியல. அதே மாதிரி ஜஸ்டிஸ் முரளிதரை இங்கே மேடையில் உட்கார வச்சுட்டு அவரை பற்றி இன்ட்ரடியூஸ் பண்ணணும்னா எப்படி பண்ணுறதுன்னு தெரியல. எல்லாருக்கும் உங்களுக்கு அவரை பற்றி தெரியும். ஸோ இருந்தாலும் இன்ட்ரடியூஸ் பண்ண வேண்டியது மேடை நாகரிகம் என்பதால் அவரை பற்றி சில தகவல்களை பகிர்ந்து கொள்கிறேன். ஜஸ்டிஸ் முரளிதர் completed his Bachelor of Science degree from Vivekananda College, Chennai, securing first class. ஏன்னா நீங்க ஒவ்வொரு தடவை கை தட்ட வேண்டியிருக்கும். அவர் எது எதெல்லாம் படிச்சாரோ எல்லாத்துலயும் ஃபர்ஸ்ட் கிளாஸ் தான் எடுத்திருக்காரு. Then he secured first rank in the Bachelor of Law course from University of Madras and awarded with the Lakshmanasamy Reddy Miller's Medal and so many other medals. As a member of law college students participating in the moot court competition, and he won the first prize again. And Dr. Muralidhar was awarded with PhD by the University of Delhi. He started his practice in 1984 and shifted his practice to Delhi. Then was attached to the office of the then Attorney General, Mr. G. Ramasamy, practiced in the Supreme Court of India. He was a pro bono advocate in the Bhopal disasters case. He was appearing for the people who were misplaced, the mentally ill and who were locked up in the jail. He represented the people who were displaced in the Narmada Dam issue. He was appointed as amicus curiae by the Supreme Court in several public interest litigations. He was the counsel for National Human Rights Commission. He was the counsel for Election Commission of India and was also a part-time member of Law Commission between December 2002 till May 2006. He was elevated as judge of the High Court of Delhi in 2006. He was then transferred to Punjab and Haryana Court as the Chief Justice. And so though the trust and these lecture series are apolitical, what I may say have a slight political thing. Please excuse me. He was about to be transferred to Madras High Court. That was not agreed upon by the. Then he was transferred as Chief Justice of Orissa High Court. What wonders he did with Orissa High Court, you have to hear Mr. Sundar and people from Rojamuthiya Library. You have one of the finest judges who were totally digitalized the entire Orissa High Court. Everything there is fully digitalized, and it's one of the pioneering High Court now is because of Justice Muralidhar. Why I said what I'm going to say have a little political tint is this. What we are now saying is North is flourishing because of the South. And he is from South. He made North to flourish. This is one of the best examples. Why North is flourishing because of the South. And because he was not sent to Madras High Court, again, whatever we say, whatever we give to union is not being returned back to us. So what we gave just Muralidhar to Delhi High Court, Orissa High Court, we wanted him to be our Chief Justice for some time at least. That was denied. It's all right. But then we are having him with us as a lawyer, as a person who is sharing his knowledge. We will be more benefited if sir is going to come and give more lectures like this. Um, I don't want to give the list of the best judgments of Justice Muralidhar, because if I am going to speak about them, he may not find time to give his lecture. So I stop with this. I once again thank Justice Muralidhar for having agreed to come and give his lecture. I thank all of you to be here. Thank you very much.
Thank you, Longa, for a nice introduction about our Justice Muralidhar. And I met him in 2007 when I was in Delhi along with the Justice A.P. Shah. From that time onwards, I know a person from our place, from Vivekananda College. I used to so attached with him, and he has done. We have done many things in the legal services and national legal services also. I think Justice Muralidhar remember all those things. And my dear students, you must be very happy. And today's topic: guilty till proved innocent. The dark areas of criminal jurisprudence. A lecture to be delivered by Honorable Justice S. Muralidhar, former Chief Justice of High Court of Orissa. Odisha was lucky, as Mr. Ilango was telling us. Odisha was very lucky to have Justice Muralidhar as Chief Justice of Odisha High Court, and we were so unlucky. But anyhow, Mr. Ilango and the foundation found it fit that we are also to be going to be lucky. That you agree with me? You agree with me? So be careful and you have to watch. And I know that you are not going to just sit and listen to the lecture, and you are going to ask questions. And I know that this is the topic guilty uh, till proved innocent. Uh, Lordship, that I actually that as a lawyer, Mr. Suresh is here, Mr. Anand is here, all our many legal criminal law minds are here, Brother Justice Muralidhar, and I do not know how you are going to keep because guilty before innocence. We always learned the basic principle of criminal jurisprudence, as we know, innocent until proven guilty. What is that? Innocent until proven guilty. That's what we are all used to be. And I'm not going to know that how we are going to match this thing because we always believed the maxim innocent until proven guilty and believed in Article 14, 20, 21, and 22. Of course, I happen to be the advisory board member and I know that where I had to apply this guilty till proven innocence also. And so over to you, Justice Muralidhar. We are eager to hear you, and I request all the students over here, everybody, including our lawyers and judges, and be ready to interact with Mr. Justice because I want to enlighten myself. What is this guilty till proved innocent? Thank you very much. Over to you, Mr. Muralidhar.
வணக்கம். Justice Anand Venkatesh, Justice Selvam, Justice Raja Ilango, Justice Akbar Ali, Ilango, Umudi Ilango, Dr. Sundar, Dr. Raghavi, and all the distinguished members of the audience, including senior lawyers. It is indeed a proud privilege to be asked to deliver the third Rakesh Endowment Lecture. This is being held in the memory of a fine young law student whose life was cruelly snatched away in an unfortunate car accident. A debt of gratitude is owed by all of us to his family, and particularly to his father, Senior Advocate Ilango of the Madras High Court, that these lectures on the theme of justice and equity are being organized every year. They should be of immense value to the legal fraternity in general, and in particular young advocates, whom I find in large numbers, and law students as well, seeking to find their feet in the legal profession. I must also thank you for organizing it in this wonderful, restored museum theater. We live in times that are both interesting and challenging. As we witness radical transformations brought about largely by technology, we also watch with helplessness the strife and chaos around us brought about by a variety of factors: persecutions and large scale internal displacements of populations, increasing polarization around caste, race, and religious lines, dictatorial and despotic regimes that make a mockery of the rule of law, growing inequalities in society with the poor getting poorer, mass spontaneous protests of the affected populations, and increased anxieties. Then there are challenges thrown up by climate change. We are told that this is the age of the Anthropocene. Nature is even more unpredictable, and our attempts at seeking to reverse the enormous damage that we as a human race have caused to nature is proving to be a formidable task. The recent Human Development Report talks of the democracy paradox. What is this paradox? Through a democratic process, you get tyrants to be elected, and they then continue ruling over you, making a complete mockery of democracy, the rule of law. This is something that Plato, the Greek philosopher, anticipated several thousand years ago. For Plato, tyranny was the final stage in the perversion of the state after democracy and develops out of strife between the demos, the populations, and the rich. The tyrant's progress starts from seemingly good intentions as a representative of the people. Plato thus assumes the tyrant is popular at first, or rather, the popular leader is a nascent tyrant. More now than ever before is the need to reaffirm our faith in humanity and in ourselves as a human race, and to find strength to be able to rise above these challenges. It is the time for all of us to reassert the basic values of a good life and reaffirm our faith in the constitutional values of equality, liberty, freedom of thought, expression, belief, the right to dignity, and above all, fraternity. The choice of today's topic was in the context of growing instances of weaponization of law to deprive people of their fundamental freedoms and bring about unintended consequences of denial of life, liberty, and access to justice. World over, we are seeing law used as an instrument of oppression, of control and abuse in the hands of powerful and dominant groups who seize executive control through elections to target their opponents. However, this is not just about law and politics, but of human rights of ordinary people. Traumatic events can bring about both the best and the worst behavior in humans. We saw that in the COVID 19 pandemic. The best in the humans surfaced. And we saw that actually happen in front of our eyes when natural disasters occur, like the floods in Tamil Nadu. We found a spontaneous overflow of human compassion and the spirit of brotherhood and fraternity. I'm going to talk about some of those events that have the tendency to change lives unrecognizably and irreversibly, and about the use of law to achieve those ends. Today's lecture is not going to be about happy things, I should warn you. In an age where law is increasingly being used in a coercive manner that challenges our long held, cherished beliefs of equality, freedom, life, liberty, as well as the fundamental tenets of criminal jurisprudence, it is both necessary and important for us to retrace the steps that brought us to the present situation. So I'm going to begin by speaking to you about three traumatic events. There are many, but these three kind of make the point that I'm trying to develop in this lecture. A tragic incident took place in a pub in Guildford, a town in Surrey County in the United Kingdom, on 5th October 1974, almost 50 years ago. This was a pub frequented by the British military personnel. A bomb exploded there, killing 4 people, while another that went off in a nearby town, Woolwich, that very day killed 3 others. Jerry Conlon and Paul Hill, two residents of Northern Ireland who had been in the area at the time of the terrorist attack, were arrested. This was, of course, later proved to be terribly wrong. At that time, there was in force in the United Kingdom the Prevention of Terrorism Act. We had an act with the same name in India. I'll talk about it later. Under this act, the Scotland Yard, that is the police force in England, were allowed to hold and interrogate terrorist suspects for 5 days without any hard evidence. Conlon and Hill, who were non political petty criminals, were among the first suspects held under the new law. During the prison stay, investigators fabricated against them an Irish Republican Army conspiracy that implicated a number of their friends and family members. The officers then forced the two suspects to sign confessions under physical and mental torture. In 1975, and this is why it's called the Guilford Four case, in 1975, Jerry Conlon, Paul Hill, Paddy Armstrong, and Carol Richardson was sentenced to a life in prison. 7 of the relatives and friends, called the Maguire Seven, were sentenced to lesser terms on the basis of questionable forensic evidence. And this is the twist. And if you want to know what happened in this case, and today's lecture, if you have your notebooks and pens or some slips of paper, please note down several films are going to be mentioned. If you want to know how this whole case unraveled, you should watch this film called In the Name of the Father, which has Daniel Day-Lewis in the lead role acting as Jerry Conlon. And I should explain to you in brief what happened in the case and how it unraveled. In their 10th year of imprisonment, in the prison where Jerry Conlon was an inmate, a lady lawyer who happened to be on the legal aid panel visited as a regular prison visit. Even today, as panel lawyers of the legal services authorities in this country, there are lawyers regularly visiting prisons to ask the inmates whether they're in need of legal assistance. Jerry Conlon tried explaining to her that he had actually a perfect alibi in the case. For those in the audience who may need to know what this is, basically what Jerry was saying is he and Paul Hill were actually in a park in London. They were nowhere in Guilford. And they were also able to tell this lawyer, lady lawyer, that while they tried to sleep on a bench in the park, a tramp who was in the park objected and an altercation ensued. Ultimately, they had to leave the park. He said, I think that tramp's statement was recorded, but it never surfaced in the trial. The lawyer then goes to what is called the police archives to unearth the preserved records of this case. She makes 3 visits, and the person at the desk, there's a constable at the desk, gives to her the same box of files, and she is not able to find anything even remotely resembling the statement that Jerry Conlon was telling her about. On one day, which is the 4th or the 5th visit, it is pouring in London. She enters this archives building. It so happens that the constable at the desk is on leave, and there's another person substituting him. He then goes in and picks up all the boxes of files. And in one of those boxes, she finds a file which says, not to be shown to the defense. This is actually withholding of evidence that can exculpate an accused person. That one document in that file was this very statement of the tramp who said, I saw these 2 boys in this park at this time. That one document helped them reopen the entire trial. All of them were acquitted 14 years after they had been convicted in 1975. As a result, 1 year later, in 1990, the Maguire Seven, who had also been roped in because of this case, they were also acquitted. Then we had an instance in 1993 of the Birmingham Six. Again, 6 persons suspected to be IRA terrorists who were convicted, and their trial was reopened, and they were all acquitted. How UK dealt with all of this, I'll come to in a few moments. The second traumatic event that I'm going to talk about is 9/11. On September 11th, 2001, horrifying terrorist attacks were perpetrated against the United States. With the transformation of commercial airplanes into lethal weapons of mass killing, a crime against humanity was committed as 2 of the flights were deliberately flown into the Twin Towers in New York. 2,753 people were killed and hundreds more were injured. Subsequently, the hijacking of another flight and its downing in Pennsylvania added 40 to the death toll. Thereafter, the hijacking of flight AA-77 into the west side of the Pentagon added another 184 victims of terrorism. Following the 11 September 2001 attacks, President Bush signed into law what was known as the USA Patriot Act. Viewed as an important weapon in the fight against terrorism, the Patriot Act, according to some, has sought to curb and prevent future terrorist acts by expanding the federal government's powers. What 9/11 did to the entire human race is something that we will all easily understand. Frisking at airports, all your baggage spanning, the metal detectors, the increased levels of surveillance, all of this. In fact, the security apparatus industry has flourished since 9/11 in unimaginable ways. You had mistaken identities. Our own Kamala Hassan had to face, just because the word Hassan was the surname of one of these people who flew the plane into Pentagon. Kamala Hassan was strip searched. Shah Rukh Khan had to face huge humiliation. And it's never been the same thereafter in our airports. Yes, yes. CCTVs, facial and iris scanners, whatnot. But this is where what is most disturbing is this. In the aftermath of 9/11, hundreds of Muslim men were rendered. This is what is called rendition. You'll find this now has become a legal concept that in Muslims in several countries were actually handed over to the US government. Sometimes the US government did not wait for those countries to hand over these persons. They simply entered those countries and picked up these men without any prior permission or anything of that sort. They were taken across borders, forcibly disappeared, held in secret detention, and subjected to egregious human rights violations. Detainees were subject to waterboarding, walling, deprivation of food and water, rectal hydration, extreme sleep deprivation, continuous noisy atmosphere while in detention. They were violently slapped, shaken, subject to mock executions, kicked, thrown to the ground, and held in solitary confinement for months. Detainees were told that multiple serious harms would befall their family members, including physical violence, economic distress, and social shaming. Detainees were subject to sexual violence, including anal penetration. The US government authorized and justified, and personnel enabled and sustained their torture. They were denied access to regular courts. They were tried, if at all, by military commissions and or tribunals. Their getting to meet the lawyers, seldom of their choice, was made impossible. How do we know all this? Actually, through several sources which are now in the public domain. So young students who are there in this lecture hall should actually go on the net and find these, which I also found and made fascinating reading. First is the report of the US Senate Select Committee of Intelligence, which was declassified and placed in the public domain in 2014. It is a scathing indictment of the US government and the CIA in the handling of prisoners taken by it from around the world in the wake of 9/11. The report, which of course has a dissent note, states the CIA's detention and interrogation program damaged the United States' standing in the world and resulted in other significant monetary and non-monetary costs. You will understand this. They had secret detention centers not in the United States, but in several dark sites. They call them dark sites in different countries so that they would not be answerable to law at all. The second source is an October 2022 judgment of the US Supreme Court in the cause title of United States versus Hussein, also known as Zubaydah. I'll be speaking often about Zubaydah. The third source is the June 2023 report of the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. Yeah, yeah. The third source is the December 2023 judgment of the UK Supreme Court in Zubaydah versus Foreign Commonwealth and Development Office. There are also two judgments of the European Court of Human Rights in applications brought by Zubaydah against Poland and against Lithuania, two countries where he was held and tortured. Zubaydah, a Palestinian, was ultimately an inmate of the high security prison in Guantanamo Bay in Cuba since 2006. He was believed to be a high-rank Al-Qaeda operative. He was detained first in an undisclosed detention center called Detention Site Green. Now we know it's Thailand. And in December 2002 was shifted to Detention Site Blue, which was in Poland. In fact, these dark sites, they had names of green, blue, and cobalt. Zubaydah's story stands recorded in the US Supreme Court judgment I spoke to you about, in which, by a split verdict of 7:2, the court upheld the US government's claim of privilege from having to disclose the location of Operation Site Blue. Basically, what Zubeda was asking the courts in the US to do was to confirm to him that he had actually been illegally detained in Poland. And although this was public knowledge by now, even a book had been written about it, the US government said no, for security reasons, we will still claim privilege, and the court should deny him this relief. And ultimately, by 7-2, the Supreme Court of the United States agreed with the government there. But the dissent is interesting. The dissent had two judges, Justice Gorsuch and Justice Sotomayor. They said it is now open knowledge that the CIA hired two contractors. In fact, the CIA did not undertake the torture itself. It hired two contractors, James Mitchell and John Jessen, and authorized them to employ what is called enhanced interrogation techniques, some of which I mentioned. Mitchell and Jessel worked on a near 24-hour per day basis, starting 4th August 2002. They waterboarded Zubeda at least 80 times, simulated live burials in coffins for hundreds of hours, performed rectal exams designed to establish total control over the detainee. In 2016, the CIA permitted Mitchell to publish a book. This is now available on Amazon. Mitchell even appeared in an HBO documentary about his activities and treatment of Zubeda. The documentary is called The Forever Prisoner, made in 2021. Again, available on the net. Justice Gorsuch notes, although Zubeda's relationship with Al Qaeda remains the subject of debate today, the authors of the Senate report found that the CIA's records do not support the suggestion that he was involved in the September 11 attacks. So a person who's not involved at all in the September 11 attacks was held for over 20 years in detention in various dark sites and in Guantanamo Bay. What is remarkable is Zubeda did not accept this and kept litigating not only before the European Court of Human Rights, but the US Supreme Court and the UK Supreme Court as well. As I mentioned, in December 2023, the UK Supreme Court gave its verdict in Zubeda versus Foreign Commonwealth Office. It noted Zubeda's contention that he was tortured by the CIA at the black site facilities situated in Thailand, Poland, Morocco, Lithuania, Afghanistan, and Guantanamo Bay. So the question before the UK Supreme Court was, in his claim for damages for this torture that he suffered, would the laws of the United Kingdom and Wales apply, or the individual laws of those 6 countries? One of his contentions was the torture he underwent in those countries was at the hands of like private contractors of the US, UK intelligence service personnel, which fact could not be denied by the UK government. So ultimately, the UK Supreme Court upheld Zubeda's contention and said it will be the laws of the UK and Wales that will apply to determine this question. The UK Supreme Court notes in its judgment that the countries and the black sites were chosen by the CIA to evade the application and protection of the US legal system and law, and the legal system and law of the country in which the site was located. In this way, individuals could be detained in what were de facto legal black holes, where interrogations could take place clandestinely without the laws of that country being invoked in practice in respect of the individuals. Zubeda's contention that he could invoke sections 11 and 12 of the Private International Law Miscellaneous Provisions Act 1975 of the UK to pursue his tort claims against the 6 countries was upheld by the UK Supreme Court. The third authentic source we have is the Special Rapporteur's report. She notes, this is a June 2023 report. Again, it's available on the net. You should read it. Every one of the 780 Muslim men held at Guantanamo Bay, including the 30 men who remain, live with their own distinct experiences of unrelenting psychological and physical trauma of withstanding profound human rights abuse. The detainee families have also suffered immeasurably. The Special Rapporteur underscores that the prohibition of arbitrary detention and torture are just cogent norms of international law, and that the US government is under a continuing obligation to complete a thorough, independent, and effective investigation into the alleged violations and sanction those responsible, provide appropriate redress and reparation to all victims, and adopt effective guarantees of non repetition, such as legislative, administrative, judicial, and other measures to prevent and punish such violations going forward. What is disturbing if one reads this report is that I speak here before you today, there are still 16 men held in Guantanamo Bay. Many of their names are not known. We only know their nicknames, names given to them by the US authorities. And we are talking of 23 years after the event. None of them has faced a regular trial. Many of them have not been charged formally with any accusations. And upon release, they're not sent back to the countries where they were picked up from. They're sent to very different countries. So in this report, you find how Kazakhstan is a place where they've been held. And when they're sent to that country, they're held in solitary confinement there. The United Arab Emirates is another such country. So it's a continuing case of continuing human rights violations of these people, not ever having faced trial, not ever having been found guilty of any offense. Since the opening of the Guantanamo Bay detention facility, 741 men have been released. Approximately 150 have been resettled to 29 countries, with the remaining repatriated, and with 30 men having died. So no accountability, no answerability. Now I'll turn to India. On 24th September 2002, a Fidayeen, a suicide attack took place on the Akshardham temple in Gandhinagar in Gujarat at around 4:30 p.m. Two persons were armed with AK-56 rifles, hand grenades. They fired indiscriminately towards the children and started throwing those hand grenades. Since the main door of the temple was locked, they moved towards the Sachidanand exhibition hall, killing and injuring several women and children. Eventually, both these suicide attackers were killed in the early morning hours, and they succumbed to their injuries received in the operation. The case of the prosecution was that a large quantity of firearms and explosive substances were carried by these two Fidaeans. The attack resulted in the killing of 33 persons, including NSG commandos, personnel from State Commando Force, and 3 other persons from the SRP group. Nearly 86 persons, including 23 police officers, were seriously injured. For almost a year, they were unable to find any leads to arrest. And after the National Investigating Agency took over, sometime in August 2023, they arrested 6 people. The trial, and they were charged under the Prevention of Terrorism Act of 2002, which was passed incidentally soon after the Parliament attack that took place on December 13th, 2001. The trial court found all of them guilty, sentenced 3 of them to death, 1 to life imprisonment, and rigorous imprisonment sentences for 2 others. The High Court confirmed the death sentences and dismissed the appeals of the accused. The Supreme Court, nearly 14 years later, acquitted all of the accused after noting that the crucial piece of evidence, 2 chits of paper in the pockets of the 2 Fidaeans, written in Urdu, were wrongly believed by the trial court and the High Court. And why was it wrongly believed? They did not have even a drop of blood, these 2 chits of paper, mud or perforation by the bullets, whereas on physical examination of the trousers by us, which were marked as muddable objects, we found that the clothes on the pockets of the Fidaeans were perforated with bullets, smeared with dried blood, even after 12 years of the incident. So law students should know what are called case properties and material objects. So even the appellate court can ask for those case properties to be produced. And here the 2 Supreme Court judges still found the bloodstained clothes of the 2 Fidaeans. So 2 chits of paper recovered from the pockets are spotless, no holes, whereas the pockets themselves are riddled with bullet holes. The letters were admitted as evidence merely on the basis of a confessional statement of one of the accused, who said that he had written the letters and had also kept the pen to prove that the letters were written with the same pen. The Supreme Court notes the High Court admitted the letters as evidence on the ground that truth is stranger than fiction by overlooking not only the most impossible fact that the letters marked by the police were spotless, but also ignoring the evidence of PW 105, who in his deposition recorded there were no signatures for the brigadier or anyone else on the letters when they were handed over to the investigating agency. And this is what the Supreme Court said after acquitting these people 14 years after incarceration. And since this was the Prevention of Terrorism Act, they did not come out even one day on bail. So for all 14 years, and for many of that in solitary confinement, they were kept in the prison. Before parting with the judgment, says the Supreme Court, we intend to express our anguish about the incompetence with which the investigating agencies conducted the investigation of the case of such a grievous nature, involving the integrity and security of the nation. Instead of booking the real culprits responsible for taking so many precious lives, the police caught innocent people and got imposed the grievous charges against them, which resulted in their conviction and subsequent sentencing. There is something deeply disturbing in each of these above narratives. That there was a gross miscarriage of justice is too mild an assessment. We are talking of countries, the United Kingdom, the United States, and India. We are talking of countries that have adopted a democratic form of government, believe in constitutional law, and two of them, the United States and India, have written constitutions enshrining guarantees to the fundamental rights to life, liberty, and in that process, to a fair trial and access to justice. Yet, in each of these cases, persons wrongly accused of the crimes that they did not commit suffered incarceration for well over a decade, losing the prime years of their life irretrievably. All these three countries follow the common law tradition. What our Supreme Court said in 2019 about our criminal justice system pretty much describes the system in the other two countries as well. The criminal justice administration system in India places human rights and dignity for human rights at a much higher pedestal, and the accused is presumed to be innocent till proven guilty. The alleged accused is entitled to fair and true investigation and fair trial, and the prosecution is expected to play a balanced role in the trial of a crime. If so, then why do such instances of miscarriages of justice take place? Why do we fail to learn from the past? And what consequences does this hold for future generations? And that brings me to the main theme of today's lecture. These cases have turned on its head the fundamental tenet of our criminal jurisprudence that a person is innocent till proved guilty. They tell us, in fact, that the opposite is true, at least in the cases of traumatic and terror striking crimes. So, how do these instances come about? First, these are cases where a special law is enacted which departs from the general rule that I have spoken to you about. The requirement, for instance, of production of a person within 24 hours of arrest. I don't know if the law students will be able to tell me the provision of the Constitution where this is indicated. It's Article 22 of the Constitution. Requirement of informing the arrested person of his rights to counsel, to know the grounds of arrest. This is also contained in Article 22. Of presumptions as to guilt, deeming crimes, all of these are written into the statute. For instance, under the TADA, if you were in a notified area and you were found with even a bullet, you would be presumed that you're part of a activity that is a terrorist activity. And it will be for you to disprove that you harbored any such intention. Confessions to police officers being admissible in evidence. This is the most disturbing part of these statutes. The only protection they said was it will be supervised by a superior officer like a superintendent of police. But the rule in our country, and which is part of the inheritance of colonial laws, is that a statement made to the police officer in custody is simply inadmissible in evidence. It's written into Section 25 of the Indian Evidence Act. Fortunately, it's still been retained in the new statutes, which are supposed to be decolonizing the law, but they realize that they can't decolonize these salutary provisions of the law. And I'll talk to you more about this so-called decolonization of the law. It's anything but that. stringent bail provisions that have a different twin test, shifting the burden of proving one's innocence onto the accused. So, in most of these statutes, whether it's the Terrorist and Disruptive Activities Act, the TADA, which was enacted in 1985, which was allowed to die, a repeal in 1997, or its successor, the Prevention of Terrorism Act, the POTA, all have provisions where getting a bail is next to impossible because the burden is shifted onto the accused to show that he's actually not guilty of the crime when even the trial has not even commenced or evidence has been tested. They have all borrowed heavily from the Prevention of Terrorism Act of the United Kingdom and the Patriot Act of the United States of America. Extended periods of detention before filing a charge sheet means that virtually detention without trial for at least 6 months is guaranteed. And this continues even under the Unlawful Activities Prevention Act that you heard of so often being invoked in ordinary cases in this country, increasingly. And in India, all of this is compounded by delays at every stage of the trial. You will be amazed to know that although TADA stood repealed in 1997, cases initiated under the TADA are still in the pipeline, either at the stage of trial or the stage of appeal, and likewise cases instituted under the POTA, which has also been repealed. And this shows, how gross the miscarriage of justice can be when ultimately these cases reach their logical end. The severity of the law is not because of its effectiveness. In fact, it is empirically established that the conviction rates, both under the TADA and POTA, were abysmally low. It is a usual response by an elected government to demonstrate that it is responding strongly to a horrific crime. No one will be spared is the refrain you will be hearing from a politician in power time and again. First reactions they will ask, the minister will say, "Sir, nobody will be spared. We will come down on this with a strong hand." And then go and enact a severe law which will ensure that the persons actually get acquitted because of impossible standards that the law sets. If you see the background to the enactment of these laws, you'll find that these are more as an impromptu response. The enactment of TADA followed the assassination of Mrs. Indira Gandhi. The POTA followed the attack on the parliament. In his floor speech supporting the passage of the Prevention of Terrorism Ordinance, the then Home Minister, Sri L.K. Advani, conceded that TADA had been ineffective as a statute and it had been misused by government officials. But he promised, POTO is different from TADA. The truth is exactly the opposite. Even 76 years after independence, we have persisted with some features of the criminal law as it stood at that time. The Criminal Law Amendment Act of 1908 has survived and is still being deployed to ban organizations. So don't get taken away by the statements that you hear that these three new laws, the Nyaya Sanhita and all of that, is actually brought about a dramatic change in the laws. It's got decolonized. None of that stuff. The Defense of India Act 1915 has constituted the basic model for the post-independence preventive detention statutes. The provisions in this statute concerning bail is the precursor to the twin test of the present identical provisions in a string of statutes. And this was an eye-opener for me. These provisions, putting the burden on the accused to show that he or she is innocent, started way back in 1915. And we persisted with this. And now it has spread into other economic offenses statutes like PMLA, like the Companies Act, which has authorized the Serious Fraud Investigating Office to exercise these kind of powers of arrest and detention. Apart from the National Security Act of 1980, the COFEPOSA, that is the Conservation of Foreign Exchange and Prevention of Smuggling Act of 1974, the Prevention of Black Marketing and Maintenance of Supplies and Essential Commodities Act of 1980, there are at least 17 other preventive detention statutes enacted by the state assemblies that enable executive detention without judicial supervision for a minimum of 3 months, and a maximum of a year without trial. In Tamil Nadu, we have the Prevention of Dangerous Activities of Bootleggers, Drug Offenders, Forest Offenders, Gundas, Immoral Traffic Offenders, Sand Offenders, Sexual Offenders, Slum Grabbers, and Video Pirates Act 1982. It must hold the record for the longest name for a statute. The Armed Forces Special Powers Act 1958, a 60-year-old law that permits takeover of civil administration by armed forces, applies even today in parts of the Northeast and in Jammu and Kashmir. It applies to the whole of Nagaland, Assam, Manipur, and parts of Arunachal Pradesh. And we have also the Public Safety Acts. The point I'm trying to make is once you have a preventive detention statute, which unfortunately Article 22 of our Constitution permits, you can actually hold a person in detention without being produced before a court for at least 3 months. And what is worse still is Article 22 says a person in such preventive detention does not have the right of a lawyer of his choice. Fortunately for us, we have the Legal Services Authorities Act, which provides for legal aid in the form of representation by a lawyer to all persons in custody, which would include those preventively detained. But the point is something more serious. These are supposed to be temporary measures in emergency situations which the state will deploy. But as Professor Upendra Bakshi says, it has become a legislative habit to govern through preventive detention and a judicial habit not to interfere with such preventive detention. So although you may find judgments every now and then with the high courts and the Supreme Court quashing a detention order, you will find that the quashing happens in the 9th, 10th, or 11th month of the detention. Because you have to travel through a whole judicial process. You first have to go before a board of 3 sitting judges who form the panel constituted by the central government. You have to show why your detention is unnecessary. In 9 out of 10 cases, that detention order is upheld by the board. Then you challenge that decision of the board before a high court in a writ petition or the Supreme Court in a writ petition, and that itself takes such longer time. So from the point of view of the executive, this is a very effective tool to lock away people who are probably opposed to the policies of the government, critical of the actions of the government, and this has therefore been systematically deployed by all governments, whether it's central government or state government, in the last 76 years of our independence. There is a myth that has persisted as well that better crime control involves more severe penal laws with harsher penalties. The earlier anti-terrorism laws like TADA and POTA, which have now morphed into the Unlawful Activities Prevention Act, have now also morphed into what is called the Maharashtra Control of Organized Crime Act 1999. This is like a prime act, and you have the twins of this act in various states like Karnataka, Gujarat, and so on. They incorporated predictable template of provisions that stand at odds with the constitutional provisions concerning criminal procedure that we noticed earlier. Longer periods of police custody, extending the time for filing of charge sheets from 90 to 180 days, making the obtaining of bail prior to the filing of a charge sheet extremely difficult. The NDPS, the Narcotic Drugs and Psychotropic Substances Act 1985, to deal with drug menace, has similar provisions, presuming the existence of a culpable mental state, apart from provisions that make grant of bail extremely difficult. It is not as if these laws have helped reduce the incidence of these crimes. I mentioned earlier, conviction rates under TADA and POTA was abysmally low, and conviction rates under the UAPA and the NDPS Acts, although seem from statistical point of view high, if you look at the pendency of cases in each of these categories, it's very, very high. What it tells us is the number of prisoners arrested and kept in prisons to the number of persons who are actually convicted or acquitted. If you compare that, it is as low as 2.8% in the UAPA cases. Of course, PMLA cases are not covered in the reports of the National Crime Records Bureau. The legislature nevertheless continues with the same pattern and has introduced statutes dealing with the same provisions in statutes dealing with economic offenses. So you have the Prevention of Money Laundering Act, the PMLA, the Companies Act, all having similar provisions. But what is worse is they are giving powers of arrest and detention to officers who are not police officers. So while under the Evidence Act, you have a prohibition against admitting a statement made to a police officer in custody, there is no such prohibition when it comes to a statement made to a customs officer, to an officer of the Enforcement Directorate, or even an officer exercising powers under the Companies Act. All these are admissible statements. And in many of the charge sheets that are filed in these cases, you will find the primary evidence being the confessional statement of the person arrested, and confession made to an officer of this nature who cannot be a police officer. And what he files will not be a charge sheet. What he files will be a complaint. So, under this facade, they evade answerability to constitutional law altogether. So self-incrimination, the right against self-incrimination under Article 20, sub-article 3, is written into our Constitution as a fundamental right. But these provisions directly militate against that. Your confessional statement made to the officer investigating your case is treated as admissible evidence in your own case. While there is confusion whether these offenses are cognizable or non-cognizable, there is no FIR registered. You have what is called the ECIR. And there's no requirement to maintain a case diary. See, one of the guarantees that a person in custody has that there is some serious investigation happening in the case and the police officers are serious about their investigation is the requirement in the law that once an FIR is registered and the court is seized of the case, a criminal court at any level of the hierarchy, that court calls for the case diary from the investigating officer. That case diary is not shown to the accused, and it's not meant to be shown to the accused, but the judicial officer satisfies herself or himself that serious investigation is actually taking place. That case diary has a serialized number of pages. You can't tamper with it. Like today's investigation will follow yesterday's investigation, will follow day before's investigation, and tomorrow's will follow today's. But in reality, something else is happening. So to avoid that, to keep a check on that, the judicial officer who's alert and who knows how the system works is supposed to ask the police officer, please show me a case diary. Now, in these detentions under the PMLA, there is no case diary concept at all. So it gives a free hand to these investigating officer to evade the rigors of the Code of Criminal Procedure and the Constitution itself. And then you have freezing of bank accounts. You have seizures. You have seizing of all devices. And there is no accountability. You have to go back to the High Court and Supreme Court to repeatedly ask what is permissible and what is not under this statute. I must digress here to discuss what is happening on the ground. There are many young lawyers here. You now have plethora of agencies. You will have the state police, then you will have the CBI, then you will have the ED, then you will have the income tax department. So it's a multiplicity of agencies chasing the same set of suspects. So if you're arrested under one law, the minute you try and come out on bail, before that they arrest you under the other law. So you have to seek multiple bails under different statutes. And like I told you, all these statutes make the getting of bail impossible. Extension of time to file charge sheet is almost routinely granted. You have section 167 of the CRPC, which grants you what is called default bail. What it means is that if you're unable to complete an investigation within 90 days, the accused can't be kept indefinitely in jail. So the law permits the accused to say, the police has failed to file its charge sheet within 90 days, I'm entitled to bail. Now, at the 89th day or the 88th day, under the statute, the prosecution comes forth to say, please extend the time for filing a charge sheet. And this is almost routinely granted by the courts. So the 6-month detention almost continues in every case. We then have redacted, anonymized, and protected witness. So if you see a charge sheet, it's supposed to be enclosed by the statements of persons who have spoken to support the prosecution. Now, if you don't know the names of those persons, they're all anonymized, given different names, whether it's under the UAPA or other of these statutes. They're given anonymized names, and they give what are called redacted statements. So where the person was when he made the statement, what is his or her gender, age, nothing is known. So very little material is available with the accused to even argue for a bail. What is also on a practical side that we are seeing in courts today is that incomplete charge sheets are filed. So even before the 180th day, you file a charge sheet and you tell the court, this is an incomplete charge sheet, I'm going to file a supplementary charge sheet. Now you have a Supreme Court judgment which says, as long as supplementary charges have not been filed, you're not entitled to bail. So that postpones your chances of getting bail. But on a very practical level, coming out on bail takes as long as 2 years and sometimes even 3 years. And you have to travel through the entire hierarchy of courts before you can be granted bail. And therefore, the costs of these litigation have gone up tremendously. The other side of it is that the judiciary is straining under the weight of these bail applications and anticipatory bail applications. So today, when I practice in the Supreme Court, I've come back to practice. The big change I can find in the last 20 years is the percentage of the cases in every court's docket of bail applications and anticipatory bail applications in the Supreme Court. So, which means there is a rejection of bail in 8 out of 10 cases in the trial courts, in 6 out of 10 cases in the High Court, compelling people to go up to the Supreme Court for granting these, for getting these reliefs. So the judiciary is training under the weight. We earlier heard of Negotiable Instruments Acts. Section 138, posing an enormous burden on the judiciary. But this is posing another huge burden on the judiciary. And at all levels of the court, I must say, very little time is available. In a bail roster in Madras High Court, I think finding 200 cases is not unusual at all. It's the same case in Orissa, it's the same case in Delhi, it's the same case in Bombay. In some high courts, you file a bail application, it may not come up even for the first hearing for 3 months. So we are having high courts now flood, means they don't have time now to take up the final hearing of regular appeals, which have been pending on the docket for years on end. We did a glance at the statistics, and although the judiciary is working very hard, every year it disposes of close to 35 lakh cases. But at the end of the year, you still have the additional burden. It's about running hard. Impact assessment that is done. We have 2 expert committee reports on judicial impact assessment, but there is no time in Parliament to even look at these. When I pass an amendment to a statute, what is the impact it is going to have on the courts? What is the impact it is going to have in the litigant public? Of course, lawyers are always very happy. More litigation. But on the litigant public, it's an enormous burden that's being placed as is a burden on the judiciary. And then there is a huge bias in the administration of law. Just as in the USA, there is an overrepresentation of African Americans and people of color in prisons, so too in India. I'm talking of just minorities, basically Muslims, and scheduled castes and scheduled tribes. The percentage of Muslim under trials in our jails is 20.9, nearly 21%, whereas the representation in the population is not even 13%. Likewise, scheduled castes, high representation of 21.6%, scheduled tribes 12.4%. And this I want the law students here to pay attention to. The major inarticulate premises of these harsh laws are A, the lawlessness of criminals can best be dealt with by state lawlessness. They are taking law into their own hands. Why should we bother about the Constitution when we deal with them? Why should we talk of the CRPC, IPC Evidence Act when we deal with them? B, that the constitutional and statutory checks on abuse of state power have made it too easy for criminals and they have to be departed from in the interest of defense and security of the nation. This is an argument that's been touted perhaps from 1915 onwards and continues till this date. C, the judiciary cannot be trusted to get it right, and in any event, the procedures are too long drawn and uncertain. Actually, the mistrust of the judiciary is one of the reasons why you have such harsh laws which draw presumptions of the status of mind of the mens rea, which draw presumptions that a person is a terrorist, put the burden, shifting this whole rule of innocent till proved guilty on its head by requiring the accused to prove guilty, which it's impossible to do in a court of law. D, torture as the main tool of investigation has always worked and since long. you will find very little discussion on torture in our public platforms. Even the judiciary is not persuaded when Ashwini Kumar, one of the members of parliament, petitioned the Supreme Court of India saying that India has not ratified the Convention Against Torture. And the court's response, of course, was, which is perhaps legally correct, that we cannot compel the union government to either ratify or do otherwise with the Convention Against Torture. But an explanation was given to the court that states' responses are awaited, that India does want to pass a law on the same lines as the Convention Against Torture, but that has not seen the light of the day. So we will still see every morning's newspapers, somebody dying in police custody and sometimes in judicial custody, being a victim of police violence or state violence. E, political and bureaucratic masters are never going to expose the police or the army to the risks of prosecution, and the sanction power is an effective shield. So once police officers are involved in a crime, to get the state government, or where, let's say, the CBI officers are involved in a crime, to get the central government, or where the army officers are involved in the crime, again, to get the central government to give permission to prosecute is very difficult. Very often, these permissions are refused. And again, refused, saying that the morale of the police force will go down, the morale of the armed forces will go down, and we need to be conscious of that, and therefore we will not give permission to prosecute. G, it is easy to sell the idea that a strong law works as a deterrent and delivers justice, particularly since public memory is short. That instant justice in the form of encounters, bulldozer actions, public flogging of suspects, tying a suspect to the army jeep and parading him, even orchestrated attacks by vigilante groups on minorities and dissenters are received well in the public and get the approval of media. So when persons in political power make pronouncements like "ghus ke marenge," people in law should be worried. Nothing is farther away from rule of law. So what it might make for good optics, and for the lay person, it might seem as if the government is really doing something to control crime. From the point of view of the law, it's deeply disturbing. Those three instances I started my lecture with are all as a result of this common perception that a strong law means there'll be better control of crime, and that all the exercise of such powers is done bona fide. As we can see, it is not so. The media very often stages all of this as a spectacle, which you view from the comfort of your homes. I remember when the war in Iraq was televised live on television, in the comfort of our drawing rooms, you could watch the carpet bombing of Baghdad. I mean, for us, it was just another spectacle. Imagine if you are living in Baghdad, you're not accused of any crime, you've not committed any wrong, and somebody is bombing your houses, right? And we easily accepted the explanation given by the US government. This was all collateral damage. And if you remember, Colin Powell went before the United Nations and actually spoke lies that they had found weapons of mass destruction in Iraq, when later it was proved to be utter lies. And millions of lives have been lost in these kind of, sensational staged spectacles. So what it does, even to the lay person, is we regularly get fed through the electronic media and, of course, through the WhatsApp, the exercise of powers in a violent manner, in an unconstitutional manner, and it's become routine. So if you see in films that somebody is getting tortured in police custody, it's no longer shocking us. As a viewer sitting in the audience and watching the film, I'm not saying, oh, this violates Section 25 Evidence Act, this violates CRPC, this violates, no. For me, it's perfectly all right. Police, like Walter Devaram comes and twirls his mustache, takes his lathi and beats someone. I think, oh, he's a very strong policeman. KPS Gill is a big hero. KPS Gill did not believe in the rule of law. I'm confidently stating that on the stage because we don't seem to realize these things. As a public, we consume all this very easily. So violence is getting routinized. And we're not questioning these things. If it happens to us, we will definitely question it. If it happens to somebody else, let it happen. So this indifference that we show as a public is another reason why these things happen with utter impunity. What all of this has done is to condone police excesses, breed a culture of impunity. There is a general pattern in these cases that have been observed by researchers world over. Tunnel vision. For instance, I am already clear into the 5th day of my investigation that these are the suspects. In the 6th, 7th day, as an investigator, I am coming across evidence that shows to the contrary. But I am impatient. I have to close this case. I have to tell the public that I have solved it, right? So ignore all those other elements that are coming to disprove my initial conclusion. So I persist with it. And this actually researchers call what is called a tunnel vision, that you are already predetermined that you have to go in this way. Hyderabad police fake encounters. 4 people were picked up for following the rape and murder of a young lady near a toll plaza. And presumably, they were taking the police to the place where they hidden some clothes of hers. The next thing we knew is all 4 had been killed. When asked how are they killed, they said no, 2 of them snatched our rifles and they were trying to shoot us, so we had in self-defense to shoot them. Fortunately, and this is only part of the story, fortunately, women's groups petitioned the Andhra Pradesh High Court and said there's something utterly fishy in this, so please have it investigated. Similar petitions were filed at the Supreme Court. The Supreme Court set up a committee headed by Justice Sirpurkar. After 2 years of sittings through the COVID period, that 3-member committee has given a report which is utterly damning of the police. 3 of those 4 persons were actually minors, something that is not being discussed in the media. And the one person who was an adult and was killed, they had nothing to show that committee that they ever snatched any rifle, tried to shoot the policeman, nothing of that sort. So today, it's been established as a result of an inquiry that these were fake encounters. And that committee has recommended they should all be booked for murder. But we still don't know what is happening in those cases. Maybe an FIR has been registered, but we'll have to watch that space to see what actually the court does. So this impunity is growing. I must draw a distinction between what I call as impunity and immunity. Immunity is when you apply for sanction and sanction is refused, you're unable to prosecute a police officer. So section 197 of the CRPC grants the police officer immunity from prosecution. Impunity, I don't register a case at all. I simply turn a blind eye. During the militant years of Punjab, over 5,000 people were cremated and their bodies thrown into the 5 rivers, Jhelum, Ravi, Sutlej, and so on. These were never investigated. It had to wait orders of the Supreme Court and then orders of the NHRC for some of the families of some of them to be compensated, but no records kept. If you went to the cremation grounds, no records kept. So we've had, for instance, unmarked graves in Kashmir now. No 128 people in just Manipur state who were encountered or disappeared. And a committee was set up headed by Justice Santosh Hegde. And only 10 cases were referred to that committee. And they found in all cases what the complainants were saying was right. And there was, FIRs had to be registered. But immediately you had a reaction from the armed forces, families of the officers of the armed forces saying, if you allow this, the morale of the armed forces will go down. We are all acting under command, under orders. So we really have a situation where many in the police force and the armed forces are enjoying both immunity as well as impunity. I think I'll skip through a lot of it because we'll run out of time. I'll just come to the last part of my lecture. Before you begin to think that it is all futile and nothing can be done, I need to remind you that just as miscarriage of justice is as old as civilization. So in Tamil Nadu, you should know that Kannagi's case was the first recorded case of miscarriage of justice. And the crucifixion of Jesus Christ is another recorded case of injustice. Just as miscarriage of justice is as old as civilization itself, so also is the fight against it. Okay, we go back to the 3 cases I talked about. As a result of the Guilford Four acquittals, the Maguire 7 acquittals and the Birmingham 6 acquittals, a Royal Commission on Criminal Justice called the Runciman Commission was announced in 1991 by the then Home Secretary in the United Kingdom. This commission went into several aspects, and among the several recommendations it made, one was setting up of what is called the Criminal Cases Review Commission. This commission actually can be petitioned by people who think they've been wrongly convicted. And if they make out a prima facie case before the commission then refers those cases back to the courts for reopening of the trial, and also provides for compensation, rehabilitation, and all of that. Like, look at the second instance of Zubaydah, Guantanamo Bay. Zubaydah took his case to the European Commission of Human Rights. He took his case to the US Supreme Court. He took his case to the UK Supreme Court. And it's been an unrelenting fight for him. But he needs closure. He needs to prove to the world at large and to his own communities that he was an innocent person. He was taken and kept in detention for over 20 years on the presumption of guilt, when actually he was completely innocent. So this should inspire you that that brooding sense of injustice that a person carries will compel that person to approach courts for justice, and you as lawyers must be available to help that person in that quest for justice. Even in India, we have constant petitioning of the Supreme Court and the High Courts for justice. For instance, when Benix and Jairaj were murdered in police custody here, courts were petitioned. The Northeast, I told you how the Supreme Court is petitioned. And Nambi Narayanan's case, he went back to the court to seek compensation. He got 50 lakhs as compensation. These may be episodic. These may be far and few in between. But it tells you that there is an answer to this. How often you do it, how well you do it is up to you. We do have a number of Godi media channels, but we also have some responsible news networks. I think I can think of Junior Vigadan here in Tamil Nadu. Web-based news outlets, they don't simply take the press releases of the police. You know, you'll find a headline saying, terrorist admits to the crime. So the person who's been arrested is already labeled as a terrorist. Whatever he tells the police in custody is already taken to be the gospel truth. And then from that point, there'll be extensive discussion in the electronic media by panelists saying that this person is a murderer, that person is a terrorist. So you'll say, if some court grants this man bail, it will say, the headline will say, terrorist walks free. Nothing could be more misleading. So there's a tremendous pressure on the judiciary as well. I must share with you one instance when I was a very young lawyer. From the Legal Services Committee of the Supreme Court, I got this case to handle. This was a person on death row. His name was Muthukutti Chandran. So he was accused and found guilty of the crime of committing a series of murders in the Kasargod area in Kerala. One of the lawyers in Kerala, and he's still around, he met me in Kochi when I gave a talk there. He was traveling on a first-class compartment from Thiruvananthapuram to Kochi. And in the same compartment in the coupe was the judge who decided Muthukutti Chandran's case. And the manner of conversation the judge told the lawyer, you know, I was under tremendous pressure by the local population, and I could not have acquitted the person, although the evidence didn't square up. So this lawyer felt very strongly about this. He says, if a judge can admit to this, that the evidence didn't square up, how can you put somebody on the gallows? So he wrote to the lawyer wrote to the Supreme Court a letter, which came to me to argue in the court. And of course, the court was not willing, despite an affidavit being filed by the lawyer, to reopen the case. But what this also told me very young, my very young days as a lawyer, that the courts, particularly the local courts, are under tremendous pressure, societal pressure, to uphold the convictions of persons whom the media has already portrayed as accused and culprits. We now have Association of Parents of Disappeared Persons, APDP in Kashmir. These are young women and middle-aged women and even grandmothers who've all come together to form this association, and they keep petitioning for justice because for them there is no closure. Some young person in their families has been picked up and has not come back to the families. They don't even know what has happened to the person. Then we have instances like Jai Bhim. You have a lawyer like Chandru who's able to fight against all odds. You have Ram Narayan Kumar. I don't know if you've heard of him. He's documented all the instances of those Punjab mass cremations, meticulous documentation. That book is called Reduced to Ashes, The Insurgency and Human Rights in Punjab. Then you have films. I don't know if you've heard of Marches by Gulzar, where he captures what happened in the militant years in Punjab. Have you seen Haider, Vishal Bharadwaj's film? It captures somewhat what happened in Kashmir. So films are another way of educating yourself about what is actually happening, but you should see the right kind of films. You should not see Ab Tak Chappan and think that is a great way to be as a police officer. Then you have documentation by what's called the Innocence India Network. Wahid Sheikh, one of the persons acquitted in the Bombay blast cases, has written this book called Beguna Kaidi. It's also available in English. And Mohammad Amir Khan has written a book called Framed as a Terrorist. This man was booked in 19 cases of different bomb blasts. And it took him again 14 years to prove his innocence to come out. So these are all available to you, around you. And what you pick up, how you go forward is entirely up to you. But the fight must go on. You cannot give up this fight because there are too many people waiting for justice. Then we have the Law Commission's 277th report on compensation for those maliciously prosecuted. I must tell you, these three new laws address none of these issues. Address none of these issues. You have a section 358 in the CRPC, which talks of compensation for wrongful arrest. It gives you 1,000 rupees as compensation. That provision remains as such in the new law. You have a section 211 for framing a false case. Again, very little or no compensation under an old law. New law makes no difference to it. The new law does not talk of encounters. It does not talk of disappearances. It does not talk of mass crimes. It does not talk of crimes against humanity. So the new laws don't address the real issues where human rights violations are taking place with impunity in our country. And it's not just about the IPC, but a string of special and local laws. If you look at the NCRB reports, you'll find a classification of special and local laws. Under that classification is all these extraordinary laws I'm talking of, UAPA, PMLA, and whatnot. So this is how we have to forge forward. So I have this request of the young lawyers to all. Question everything, particularly unverified assertions of facts and be suspicious of power. Don't ever become a bhakt in any public figure, political, social, religious, or political. Where the question was, do you follow DK Basu? The answer was, no, he's not in our history sheeters list. We don't. Another funny episode. There is a competition for the best police team in the world. So the competition is very simple. You have to enter a forest and catch hold of a fox. So the French team goes in, and within 3 minutes, the fox has been caught. How? They've found a perfume. You spray the perfume, it attracts the fox comes out. The American team is sent next, and they've perfected the mating call. So they imitate that mating call, the fox comes running out. Then the Indian team goes in, And it's already late in the afternoon, 4:35, no sign of the Indian team. 6, 6:30, again no sign. Then a search party is sent in to find the Indian team. The search party goes to the middle of the forest and finds a small clearing between two trees. A bear has been strung up, and these chaps are beating it, saying, "Kabul kar tu lomdi hai." Basically saying, admit that you're a fox. I want you to have role models to emulate, because you will find in your life as a criminal lawyer people asking you always, how can you defend criminals like this, right? As a lawyer, you should know, after hearing this kind of examples, that whatever is told to you, that this person is a criminal, this person is a terrorist, don't take it for granted. Question it. Ask to be satisfied. And as a lawyer, you're standing up for whatever that person has to present before a court. You have he or she has a right to silence. You respect that constitutional guarantee. She has a right against self-incrimination. You respect that. He or she has the right to say, my statement made to the police officer should not be acted upon. Say that. Don't twist facts, don't twist evidence, but please place the case that the person has before the court. That is your fundamental duty as a professional. Just like a doctor will not refuse to operate on a terrorist who needs a heart surgery or a kidney transplant, you as a lawyer should not make these kind of choices. Leave it to the courts. The courts will decide whether the person is guilty or not. You do your fundamental professional duty of defending the person to the best of your ability. People in the audience must be wondering, okay, this person goes on talking about the accused, human rights of the accused. What about victims? Right? In the media, you'll always find when somebody says this person who's arrested has been treated unfairly, another panelist will say, what about the victim? And they will position rights of victims versus rights of accused. That's a wrong equation. One doesn't score out the other. It is not a zero-sum game. You have rights of the accused, you have rights of the victims. You can respect both. No victim will feel satisfied if a wrong person is put in jail. And remember what Father Naimullah said during the Nazi regime. If you are indifferent to the way the criminal justice system works, it might entrap you as well. So be vigilant, be alert, and be like my big hero, Kannabiran. So we'll start at the 20th minute. This will take just 4 minutes, but it's so important for every young lawyer to watch this. Kannabiran was a senior lawyer. He's no more. He's been my eternal hero. I get goosebumps every time I hear him. So I'm going to get, I know I'm going to get them now again. But he stood up for very difficult cases and fought them till the last breath of his life. So please hear what he has to say.
Funny part of it is similar cases, conspiracy cases. 22 conspiracy cases were framed within a period of, say, from 69 to 74.
74లో సికింద్రాబాద్ కుట్ర కేసు వచ్చింది. ఆ సికింద్రాబాద్ కుట్ర కేసులో విప్లవ రచయితలే 6 ఉన్నారు. చివరికి ఎంత అంటే టెలిఫోన్ డైరెక్టరీలో కూడా విప్లవ రచయితల కుట్ర కేసు అని దాని ఫోన్ నెంబర్ ఇవ్వబడుతుంది.
It's a part of history of this civil liberties movement that Kanna fought our case for 18 years without a single paisa charging us as fee. Not only that, in our case, there were so many accused who were small farmers or their wives and all that. They used to come to Hyderabad. They were penniless. Kanna used to provide them boarding and lodging and even to and fro charges. That way, at that time, let me tell you, Kanna had a very prosperous practice. He was legal advisor to Paris and Company from Tamil Nadu and so many other 5-star hotels, clubs and all that. His practice suffered a lot because he took up our case. He became known as Naxalite liar.
But I would personally feel that the government was interested in prolonging the matter. You harass them completely. So you have the accused who were married then have become fathers. Some accused have become grandfathers. And I was the only one constant feature. And then after the PP's argument in October, the judge asked me, when will you have your arguments, Mr. Kannabiran? Then I told the judge very solemnly, saying, sir, I took up this case when I was 40 years old or 45 years old. And now, sir, I am 55, I think, 45, 15 years, 40 years old. I'm 55 now. And my birthday falls on 9th November, that is a Monday. Please have it on that day so that I can commence my arguments. So the next day, the accused got flowers, birthday gifts, bouquets, and all that. Empty con, not a huge bouquet.
1972 నుండి చూస్తున్నాం మేము చిన్నగా ఉన్నప్పటి నుండి. ఈ 30 ఏళ్ల సుదీర్ఘమైన జీవితంలో ఎప్పుడెప్పుడు ప్రజల ఉద్యమాలు వచ్చినాయో, ఎప్పుడెప్పుడు విప్లవ ఉద్యమాలు వచ్చినాయో అట్లుండవు. అదే కాదు, ఏ నక్సలైట్ల గురించి చెప్పుతే భయం రా బాబు, నక్సలైట్ గురించి మాట్లాడితే భయం అన్న పరిస్థితులలో ఆ నక్సలైట్ ఉద్యమాన్ని గురించి, ఆ విప్లవ ఉద్యమాన్ని గురించి కంటిన్యూగా మాట్లాడడం. అదే కాకుండా వాళ్ళు చేసే తప్పుల్ని కూడా నిర్భయంగా ఖండిస్తాడు. అదొకటి. దాచుకోడు. కోపానికి వచ్చిండు అనుకో, నువ్వు ఇది తప్పు చేస్తున్నావు, నువ్వు ఇది తప్పు చేస్తున్నావు, మీరంతా పాడైపోతారు రా, మీ చెప్తే వినూరి, మెల్లగా తీసుకోపోయిన మూమెంట్ అని కూడా గట్టిగా చెప్పగలుగుతాడు. తన మనసులో ఉన్నది మనకు కొంచెం ఎమోషనల్ అయిపోయింది అనుకో, ఇంకా ఏం మిగలదు, అంత చెప్పేసేస్తాడు.
Mr. Kannabiran, these Naxalites who want to overthrow the government, overthrow the constitution and all that, why should say they seek protection under the constitution? Then I told them, sir, when such values come before this court, it is not their values which are on trial, but your values. Your values are in trial. Your constitution is on trial. You write in the constitution saying people who don't believe in the constitution are not entitled to protection. There's an end of it. So long as you say that notwithstanding their views, they are entitled to rights and protection under the constitution. It is your values, your constitution, which is always in trial.
The Indian constitution is
In another place in this film, he tells you how it's not the constitution that gives you the rights. The constitution recognizes the rights you already have. And those rights have to be asserted time and again. You must develop a habit of asserting constitutional rights if you want to preserve this democracy. So I think I've come to the end of the lecture, but my request, we need a strong and vigilant bar as much as we need independent judges at all levels. We talk of independent judiciary only about the High Courts and Supreme Court. What about that magistrate working in those trying conditions, feeling so much pressure just from, not from society, from the police and from all quarters, and from his bosses in the High Court? His ACR should not be spoiled by some High Court judge. All tensions. The person works under those conditions. We need to ensure independence of that judge at that level. We need to be an informed public that will stand up to injustice. It was Eleanor Roosevelt who said, where after all do human rights begin? In small places close to home, so close and so small that they cannot be seen on any map of the world. Yet they are the world of the individual person, the neighborhood she lives in, the school or college she attends, the factory, farm, or office where she works. Such are the places where every man, woman, and child seeks equal justice, equal opportunity, equal dignity without discrimination. Unless these rights have meaning there, they have little meaning anywhere. Without concerted citizen action to uphold them close to home, we shall look in vain for progress in the larger world. The Zubaidas, the Amir Khans, the Wahid Sheikhs are shining examples of people who have survived enormous ordeals to tell their stories to all of us, and yet not give up hope in their struggles to seek closure and justice, not just for themselves, but for the silent suffering humanity that is victim of state excesses. Let us strengthen their hands and their hopes and join them in making this world a better place for all of us. Thank you so much. Thank you.
Thank you. Thank you. Can I request you for a few more minutes? We are going to close. And I do not know. I have no words at all, Mr. Justice Muralidhar. For your information, I have prepared certain questions for Mr. Justice Muralidhar. I'll just read the questions alone, and I'll tell you what happens. I prepared a question anticipating that he is going to defend something of this type, and I will prepare a question that how do you say that when the offender is brought before law, having committed an offense is to be treated as innocent, as a process of proving his guilt is lengthy and cumbersome? He has already answered that. It's not right? He has already answered that. Then I was having a question, what about the victims? Should they suffer till the guilt of the offender is proved? He has already answered that. And I had a question. These are my question. Now he has not given me. Don't worry. It's my questions. No. Are the preventive detentions to be considered as guilt before the innocent? His first point is that should they be treated as a guilt? Are the laws against the law have-nots and not against haves? He has already answered that. All these are against haves or have-nots. You know where have-nots are inside. If the haves are enjoying innocent until proven guilty, should the poor suffer guilty until proven innocent? He has already answered. And now the house is open to you. I expect many of you, the main legal luminaries are there, and our former prosecutors and the present senior counsel, the judges are here, and the prosecutors are here, and the law students are here. Just question, any questions that you want to ask, please. Anybody? The first other questioner? Somebody? Please come. Yes. Yes, sir.
Sir, my question is, in the case of Mr. Gautam Navlanka in the Supreme Court has given him, accepted his request of house arrest, still pending trial. What is your opinion on granting house arrest at the request of the accused?
I handled the case myself. Rather, somebody else should talk about it. I actually gave an order in that case. So, you read the judgment of the Delhi High Court and now the Supreme Court later. All right. See, I think what you should, Vijay, what you should also consider is not just that one case in isolation. There are, I think, 18 accused in the Bhima Koregaon cases. See what has happened in all those cases. When were they arrested? When was charge sheet filed? Why charges are not framed? Right? It's 6 years since they were arrested. So that is what you should look at, and how difficult it has been for each of them to get bail. Each of them had to come to the Supreme Court to get bail. So that's something that tells you how the law is actually working on the ground. Yes.
May I please, my lords?
Yes.
Lordship may throw some advice to the young lawyers here and the juniors, how to become successful lawyer and a good judge like you.
They will make the good judges if they are good lawyers. In order that there is no miscarriage of justice in court, in order that an overruled judgment is not cited, in order that a relevant provision is actually shown to the court and not kept away from the court, you need to be alert, updated, and have a voracious appetite for reading. And reading across disciplines, not just law. You open the newspaper Hindu, straight go to the sports page, ignore the editorial page. Won't work. As a lawyer, you must be able to read, comprehend, write down what you've read, and then speak. So the sequence is read, write, speak. If you speak without writing, disaster. So you'll find lawyers who draft their own petitions are able to argue better in court, better than senior lawyers who argue others' drafts. So this is and be alive to realities in society. People coming to you are coming in distress. Let them not leave you in greater distress. People coming into the system are coming for relief. Let them not go from the system, making their lives worse. These are simple rules that you set for yourself. But imbibe constitutional values at a deep personal level. If you're a lawyer who says, I'm an ADMK lawyer, I will not deal with the DMK case, a DMK lawyer, ADMK case, out. You've lost your professional privilege to be a lawyer. If you have compulsions like, I'm a vegetarian, I will not deal with cases of non-vegetarians. You cannot be a lawyer. You must believe in secular values. You must believe in constitutional values of the right to equality, non-discrimination, liberty, dignity, and fraternity. Practice these values in the bar. Don't allow the bar to be captured by forces that don't believe in constitutional values. This is my earnest request to you. If you don't practice constitutional values in the bar, you can't fight for them in the court. If you don't practice them in the bar, you cannot expect judges who are from amongst you to uphold those values. So firmly believe in constitutional values, practice them at a personal level on a daily basis. You can't be a lawyer who beats up his wife in court and argues a protection of women against domestic violence act in the court. You need to practice this on a daily basis. So this is my advice.
Thank you so much. Thank you so much, my lords.
Good morning, sir. Hi.
Good afternoon, Bo.
Good afternoon. Yes.
Sir, please.
Thank you, Justice Muralidhar. Your lecture could well be a research paper publishable in any of the law journals.
Thank you.
My question is on the attitude of the judiciary. National security and terrorism on the one hand, and serious economic offenses on the other, seem to be magic words that halt the judiciary in its tracks. Why do the judges give the executive such a long rope in these two kinds of cases to violate the basic tenets of the rule of law?
See, one is, I think, the tendency to believe that the state must be right. So the questioning, that's why I say as a lawyer, you should begin questioning. Don't take everything that's put before you for granted. So you must develop the ability to question, the ability, but for which you should be informed, right? If you do not have enough information, you cannot put the relevant question. A prosecutor comes before you, he produces sealed cover. He says, sir, I'll show it to you in sealed cover. Cannot show it to anybody. So that is, many judges fall for that. They don't say, listen, file an affidavit claiming this privilege. There is a provision in law for that, claiming privilege. But many judges get overawed. They simply take that sealed cover and think, oh, there's something so, serious about it that we should not look into it. So it also comes from having a wide range of practice and fighting establishment. So if you find a majority, I'm not saying all judges are like that, a good lot of judges are picked up from among government leaders, prosecutors. So they are less willing to question state excess or state authority. It happens. I mean, there were Earl Warrens. Earl Warren was thought, he will go with the government of the day. He proved them completely wrong. We've had instances of judges who've been fearlessly independent, irrespective of their past. But we're talking of the run-of-the-mill, regular judges who can easily get overawed if the government comes before them and says, this is high security, defense of the nation, all of that. They should develop the ability to question even that. And as a high court or as a Supreme Court, that is the power you have. After all, the government is accountable to the rule of law. And you as a court are to enforce that accountability. That's the primary role of the court. And I don't see why they should simply accept. Like if you look at the media one, sir, because you're from the media one case of Kerala, which went to the Supreme Court, they tried saying the same thing to the Supreme Court. All defense of the country, security of the nation. The Supreme Court saw through that, saw through the materials and said, no, we don't find these as acceptable explanations for why you're denying renewal of license to this media house, and allowed their petition. It's a wonderful judgment, answers the point you're making, but we need more courts like that to take this forward.
Yes, sir. Thank you. Sir, what is the main reason for delay of judgments? Because we have a DK Basu 11 guidelines. Then too, we have a delay of judgments. What is the main reasons of the delay of judgments?
Yeah, several reasons. One, of course, is the overload of cases. See, judgment writing is an art, it's a skill. If I've heard 5 cases today of reserved orders, tomorrow I hear 5 cases of reserved orders. By the end of the week, I have some 30 reserved cases, right? I'm supposed to start writing over the weekend, which is Saturday and Sunday. The first case I reserved. I've already traveled some 6 days away from that case, right? So I have to recall all those arguments. I have to write a proper judgment. If I want to write a perfect judgment, I can't write it in a hurry. Some judges have developed the skill of being able to dictate then and there. It happens with some years in the judiciary, but not all judges are well versed in that. Another factor is what happens actually in court. The role of lawyers is very little spoken of. It's as if the entire delay, the cause is only the judiciary. The number of lawyers seeking adjournments. If you're sitting in court and watching court proceedings, you will realize that. Adjournment sought by the defense lawyer or the prosecution, one or the other. So you have variety of reasons. Records not being ready, witnesses not being ready. The CBI has a list of 80, 100 witnesses. If this was supposed to produce 3, it doesn't produce even 1. You have to adjourn it. So I'm saying there's such a whole variety of factors that contribute to delays in courts. We've, I think, unfortunately put the entire blame only on the judiciary, and we've not actually seen how many people are contributing to the delay. So I think it's a complex question, but the simple answer is overload of cases. It's like an overloaded vehicle. A 4-seater car la நீங்க 10 பேர் உட்கார்ந்து வச்சீங்கன்னா கார் எப்படி நகரும்? நகராது. என்ன டிரைவர் போட்டால் even a shoemaker comes there and drives, he can't drive that car beyond 10 kilometers an hour. So, the judge population ratio also is very low. So, and you'll be surprised to know it's not easy to find from among lawyers judges with the capacity to be a good judge. So that's a different task altogether. You need enormous patience in listening to cases, doing the same things over and again from morning to night. So I can say now confidently after 17 years of being on the bench that it's a very complex question. We've tried to simplify that question and give a simple answer, which is what is leaving us all dissatisfied.
Good afternoon, and thank you for an excellent lecture, Justice Selvam.
Hello.
I am going one step beyond guilty till proved innocent. In fact, I might be roughing a few, but we have situations where trial advocates are telling us that the judge at the completion of the trial informs yours is a good case, take it up in appeal and convicts. How are we going to meet that situation? I think it's a very dangerous thing. The difficulty is the district judiciary, the subordinate judiciary, are running a little scared of being knocked on the head by the administrative judge or by whoever looks at the ACR. So this is an issue, I think.
Correct. Actually, this is calls for a soul-searching introspection. See, when we have our meetings with our district judiciary, we must instill them in the confidence that just because they grant a bail, they will not be suspected of having done something wrong. So, in fact, in Orissa, you'll be surprised to know, sir, there was an instruction that every bail order, whether it's anticipatory or bail, granted by any court in the district judiciary, a copy should be sent to the High Court. That had such a chilling effect. So when I took over as Chief Justice, I first withdrew that order. The minute you think you're going to be watched so closely for every order that you pass, you'd cease to function. So you're right, we need to introspect, we need to instill the confidence in the district judiciary that their primary function is to decide bails on merits and not out of fear.
We are grateful, Milad, for your lecture. You are enlightened as well. But that is a right between the accused and the victim, as your Lordship has explained.
Correct.
But after 15 years or 14 years, or even at 20 years, a person who is incarcerating in jail, either the High Court or the Supreme Court, as the case may be, at last is a fine that they are innocent. What would be the compensatory mechanism, Milad, unlike this Naminarayan's case? None of them are being compensated for the valuable life they have spent in incarceration for more than 15 years.
Correct.
What would be this government or the judiciary is going to step up or for rehabilitating the person who was convicted or not convicted and incarceration drugs?
So, like I said, there's a Criminal Cases Review Commission in the UK, and the 277th Law Commission report has suggested a series of measures and compensation, not just monetary compensation, rehabilitation in terms of removal of disqualification. For instance, I've been acquitted in a murder case. I apply for a job. There's a column says, have you ever been convicted of any offense? I have to say, yes, I was convicted, but in appeal it was reversed. The minute the prospective employer sees that, he says, I want nothing to do with this person. So you suffer disqualifications for admissions to employment, admissions to institutions. So the Law Commission report is very interesting reading. It, of course, refers to literature all around the world and says that we have to do much more than mere monetary compensation. The thing is, Law Commission reports are not read by anyone. This report was given in 2019. And when we passed these three new laws now in 2024, I think nobody in Parliament even bothered that this was an important aspect to be addressed. We have also enormous and enough examples of countries abroad, New Zealand, Canada, Australia, of course, England, US, where you have schemes for compensation for persons wrongly convicted. Likewise, victims' compensation. There are enough schemes. Witness protection, for instance. This was a wonderful opportunity to put in the statute witness protection measures. Not done. And we are claiming that we've somehow ushered in a fantastic set of free laws, which is going to usher in a new era. No, it doesn't address many of the problems that we've been talking about today. So this requires serious debate, very serious debate. Thank you. Thank you for the question.
Good afternoon, sir. I'm Karthik, a second year law student.
Yes. Can you put up your hand? There you are. Yeah.
Yes, sir. So my question is, has our pursuit for instant justice started downplaying our journey for getting the actual justice? Like you mentioned the Hyderabad rape case, right? In that we had a fake encounter and people started nonchalantly celebrating it. So have we started internalizing this feeling of getting instant justice, but not the actual justice, something which is just satisfying our ego? So is this becoming very prevalent among the minds of people, and has media also spiced up this feeling?
First, I'll ask you, when you say we, qualify that we, all right? It's not that all people are celebrating. Some who know how the system works are not celebrating. First, you must decide you want to be part of those people who are not celebrating or part of the people who are celebrating, right? That's point number one. Second is, it's only through more education and being more informed that you can question this. See, this reaction of the public or the mobs to instant justice has always been there from time immemorial. It's nothing new. We are hoping that with better education and better awareness, there will be a refinement of thinking and a more mature way of responding to these situations. But we have to work at it. We have to constantly work at it. We shouldn't be regressing, which is what the media is now doing. I'm talking of the major news channels and television and all of that. Instead of helping us think more rationally, they are asking us to abandon rationality. And that's a disturbing thing. But law students, lawyers can contribute a lot to changing this perception of the society. So you have a big task ahead of you.
Thank you for the magisterial lecture, Lordship. In fact, as an extension to that question, of late, you did speak about biases being formed, but there's also the problem of technology today that can actually exacerbate this problem, or is exacerbating this problem, deep fakes and all of these things. And I actually have a disinformation research group in London, where we are looking at it on a day-to-day basis. How does then the court regulate or legislate on this? Or
the court doesn't legislate. Let me make it very clear. The court informs itself. See, judges, we do go to judicial academies where there are short-term courses or lectures given on newer developments in the law, including your electronic evidence, cybercrime, but we need to do it more intensively. So that's one way. We have a Tamil Nadu State Judicial Academy, you have a National Judicial Academy, and you have regional academies. Like in Coimbatore, there is a regional academy of the Tamil Nadu Judicial Academy. So these places are where we hope to expose judges. We call speakers from different disciplines, even discipline of science, to tell us, or computer experts, to tell us how this technology works. And in court, you will find expert evidence. So that's what I'm saying. It's all about your own individual level reading and ability to digest all these technical concepts. But it can only happen through greater exposure and greater learning, that you will be able to question even an expert. whether what the expert is saying is right or not. It's a huge challenge. The technology thing is a huge challenge. Yes, please. Yes, madam.
Good afternoon to everyone. I'm Sudhara Malingam. I have been associated and worked with Mr. K.G. Kannabiran a lot. He was our mentor. So I just wanted to share a few things. That is, he is a person who used to talk about how you have to make the magistrates understand that constitution is something with which they work. I think towards that, Rakesh Foundation should actually take it up. The most important thing right now in Andhra Pradesh, a letter by Ravi Chandar has been taken up as a suo motu writ petition where the people have been brought handcuffed. This is happening routinely even in Tamil Nadu. I think such instances could also be taken up by this foundation, and we also perpetuate the memory of K.G. Kannabiran. Likewise, I think that's something which I would like to appeal to you. Thank you, Mr. Muralidhar. It was a great pleasure to listen to you.
Thank you. Thank you. Yes, yes. Correct. Actually, we are regressing. When you keep the statute and the human rights documents side by side, even our own constitution, you can see how much we are regressing in the area of lawmaking, in criminal law. So I think we all need to speak up, invoke Kannabiran wherever we can.
Hello, sir. I was privileged to work with Murli, sir, and his attitude while working with juniors is very calm. I have a small question, sir. Always young lawyer while defending accused, and which are subject to media trials, where it is already portrayed that that particular accused is difficult. While taking up such cases, it becomes a stress for a lawyer, whether how to present him in a perfect manner, because while taking up the matters, they are already portrayed as criminals. While taking up such matters, how do we manage that stress? How do we not become a judge and only do our advocacy? Because that becomes a difficult task. So can you enlighten on that?
Look at the examples. Of course, Kannabiran is a big hero for all of us. There are several examples around you of lawyers taking up very difficult cases. You'll have one lawyer stand on this side and a whole battery of senior lawyers on this side, right? And this one lawyer is so well prepared, gets the audience of the judge. So how well you're prepared, how calm you can be. See, this is very important. You're a professional. The important thing to note is don't use rhetoric, don't get emotional, and don't identify with your client. Of course, you're representing the client, but don't identify with the client. Present your case as professionally, competently as you can. This is only through sheer, years at the bar and watching people around you can develop these skills and connecting with the judge. So all that is important. You earn the respect of the bar when you stand up like this in a difficult case and argue. It doesn't matter whether you lost the case or not. That you're able to stand up, withstand that pressure, still address the court, place your arguments is what will mark you out as a good lawyer.
Good afternoon, sir. I consider this as my pleasure to be a part of this lecture because I came to know a different concept. And sir, whenever a person is declared as guilt or declared as innocent or gets a bail, he or she has to face the societal shaming and his family too. So creating awareness among society about the rights of an arrested person and the judicial stuff which is happening into this like happening in judiciary. So we need to create awareness among them also because they the arrested persons after he gets.
Your question.
Sir, what would you like to suggest the society about this thing, sir?
No, I've already done that during the course of my lecture. So
actually, this is our duty to create an awareness among the society because as law students, we need to change this. So they can lead a dignified life through this.
How well you're informed is very important. Recently, I went to a law college. I gave a lecture. I asked them to name 5 of the current sitting Supreme Court judges, and not even 2 of them could name all of them. So, so how much of reading you do, analysis you do, will give you the right answers. But be at it. Don't stop. And there is no dull day for a law student, definitely not for a lawyer. And today, newspapers, the proportion of law news is fairly high. I think Mr. Ravi would agree with me. So there's so much for you to read and ingest.
So good evening, sir. I just have a basic doubt. What is the difference between not guilty and innocent? When would you call someone not guilty, or when would you call someone? Or is there a difference at all?
Yeah. See, the point is,
I first, again, like I told you about films, watch this Kurosawa film called Rashomon. All right. See, Justice Albie Sachs told us that what we do in courts is find microscopic truths. We don't find dialogic truths. We don't find experiential truths. We don't find logical truths. We find microscopic truths. By microscopic truths, what do you mean? For this situation, I'll only have close-ended questions, yes or no, right? I'll use the yardstick of admissible, inadmissible, relevant, irrelevant. So we have got rules of evidence which traps the facts in a certain dimension, and we address that. Whereas if there's a dialogue between an accused and alleged accused and a victim, more truths might emerge. So at the end of this whole exercise, which is about truth seeking, we can't be 100% sure that we've arrived at the truth. Rashomon tells us that you looking at me from there and she looking at me from here are seeing two different things. The same event can be described differently by different persons. So what we do in court is not a complete foolproof exercise at truth seeking at all. And it's subject to different interpretations, different points of view. As judges, we then actually become philosophical in learning to accept this reality too, that what we say in court is not the final word at all. In fact, they go beyond. You have a review petition, you have a curative petition, all of that. So in a sense, in that sense, in the court is the failure of the prosecution to prove its case, right? So factual innocence will be going to be very hard to establish. So how do I show that I was not there? Correct? For instance, there's only so much I can do to prove it. If I haven't thought of today, I should preserve, this air boarding pass that brought me from Delhi to Madras. I have no think of preserving it, right? 5 years down the line, I'm asked to show whether I was in Madras or I was in Delhi. I don't plan for that, right? So I'm saying the innocence that we talk about is the failure of the prosecution to prove its case, and not that we found who the perpetrators is. So it is a different concept from the factual innocence is different from the no guilt result that we arrive at in court. I don't know if I've answered you. Right.
Thank you, Your Lordship, for enlightening. And now I request Akhilesh to thank the gathering, please.
On behalf of Rakesh Law Foundation, I would like to extend our heartfelt gratitude to Honorable Justice S. Muralidhar and Honorable Justice G.M. Akbar Ali for accepting our invitation and for being here with us today. Honorable Justice S. Muralidhar, your original thinking on law and the way you had delivered the lecture was extraordinary and have truly inspired us. I am sure you had given a different perspective to all of us. Honorable Justice G.M. Akbar Ali, we need not thank you since we are a family, but thank you for your constant support and care. It means a lot to us. Finally, I would like to thank all of you present here, particularly Honorable Justice Raj Elango, Honorable Justice C.T. Selvam, Honorable Justice Anita Sunan, Honorable Justice Anand Vengesh, Honorable Minister Mr. K. Ponmudi, Minister for Higher Education, R.S. Bharati, former Rajya Sabha MP, P.K. Selvam, former Rajya Sabha MP, Senior Advocates R. Shanmugasundaram, former Advocate General, R. Vidudalai, Mr. A. Ramesh, Ravi, Hindu Group, Mr. Balakrishnan IAS, RMRL Trustee, Mr. Sundar, Director RMRL, staff members of RMRL, State PP, Mr. Hassan Mohammed Jinnah, State Government Leader, Mr. Edwin Prabhakaran, all Additional Advocate General, all law officers, DMK Legal Wing, advocates and law students, all my colleagues and trustees of Rakesh Law Foundation, event management, photographers, videographers, press and media, catering service, Greater Chennai Corporation for the venue, and Greater Chennai Police. Thank you one and all. Happy birthday, Rakesh. National anthem.
जनगण मन अधिनायक जय हे